The broadcast is now starting. All attendees are in listen-only mode.
Good morning, everyone. My name is Renee Miner, and I am the Adult Protective Services Consultant. I want to welcome you all to the webinar regarding Adult Protective Services Residency. First, let me just go ahead and just bring your attention to a few things regarding how to view a webinar, just in case you're not already familiar with that. So on the screen in front of you, you should see a control panel on your right-hand side of your screen. It should already be open, but if it's not, there is a red box with a white arrow. And if you click on that, that is what actually opens and closes the control panel up. You can listen to the presentation in one of two ways. The most preferable way is through the telephone, but you do have an option to also listen through your computer speakers. If you wish to hear the audio by phone, on your control panel, and again, if it's not already open, click on the red tab with the white arrow. Once you click on that, you should see a tab that says Audio, and then you would select the telephone option. And then at that point, you should see a phone number displayed. And so at that time, you will call the phone number provided and also put in your access number and PIN number when the telephone system prompts you to do so. So that is the best way to hear the webinar. But again, I want to stress that you do have the option of listening through your speakers. Everyone is automatically already muted, so you don't have to worry about muting your phone unless you just want to, your personal preference, that's fine. But just want to let you know you are muted. Even though you are muted, you can still ask questions during the webinar. However, we will not address them until the end. So when you think of questions or questions come up, we'd like for you to go ahead and type in your question on the control panel. So if you're looking at your control panel, you should see a tab that actually says Questions. And when you click on that tab, you should see a small box appear where you can actually type in the question, and then you would hit click to, then you would click Submit to send your question. So that way, once we get to the question and answer session, we'll already have everyone's questions there. Okay. I hope you had the opportunity to receive the email I sent out to all the registrants yesterday with the materials that we are covering. But just in case you did not, you will also see on your panel, control panel, that the handouts are loaded for you. We have the webinar PowerPoint and the APS Residency Manual section, the actual Adult Protective Services intake tool, and then as well as the appendix. And we will be talking about all of these in detail shortly. Okay, so now that we have that out the way, we'll go ahead and begin. So as I stated, I'm Renee Miner. I'm the Adult Protective Services Consultant with the Division of Aging and Adult Services. And also presenting with me today is Rick Hall. He is an Adult Program Representative with the Western team, also with the Division of Aging and Adult Services. And we also have today Raj Premakumar. He is the Assistant Attorney General with the North Carolina Department of Justice. Raj will be speaking later during this session regarding legal intervention. I also want to make everybody aware that we also have listening in today Nancy Warren. She is the Program Administrator here with the North Carolina Division of Aging and Adult Services. Our goal and objective for today is, by the end of this webinar, we hope that you all will have a better understanding of the practice regarding Adult Protective Services report received when the disabled adult is not located in their county of residence. And before I move on, I just want to point out that there is no change in law or statute. General Statute 108A has not changed. So this webinar or this practice is not as a result of anything that has changed in the law. This is a clarified guidance and practice. That is the purpose for this. So just keep in mind that we are still operating under the same law as before. We're going to begin by just talking a little bit, giving you an overview of how this came about. When we're talking about Adult Protective Services residency and why we're talking about that. And the conversation began as a result of here in the division, we noticed and realized that there was a lot of discussion and questions and comments and concerns being shared with us surrounding situations when adults end up hospitalized outside of where they reside. And this caused us to realize that we needed to have discussion about that. Even though the initial conversation started with the focus regarding individuals being hospitalized in a county different from their residence, we eventually realized that this really applies to other situations as well. So as a result of beginning to have that discussion, a work group was formed in collaboration with the North Carolina Association of County Directors of Social Services, also with the Division of Aging and Adult Services, as well as representatives from County Department of Social Services and staff. We had staff representing the Western, Central, and Eastern regions as a part of the work group as well. So we all came together and discussed this issue. And like I said, initially we were focused on the concerns about those being in the hospital and how counties respond to and or receive and screen those reports. During the meetings and discussions that the group had, we found that counties were operating and handling this particular practice a number of different ways, and there was no consistency, which made us realize that there was a need to develop and implement clear guidance. And it's not just about, again, where the disabled adult is hospitalized, but when they are actually located outside of their county of residence. We realized that the first step was to gain a better understanding of the law and policy and how it applies to this practice. So in order to get this, we partnered with the Attorney General's office, Raj Kumar specifically, and he is, like I said, on the webinar today as well. So Raj assisted us in understanding the law better and the statute and how it actually applies to this matter, which we gained a clear understanding of the law and the administrative code and rules as well. This understanding helped us learn the terms of the responsibilities that counties actually have when a report is received on an adult that actually resides elsewhere. We learned that the administrative code and the rule actually gives us the clarity as to how the statute should be applied in practice. The statute, however, states that both the county of location and the county of residence have weight in terms of their responsibilities in providing protective services for the disabled adult. However, the administrative code and rules actually dictate that it is the responsibility of the county where the adult resides or where they call their home for the evaluation, case decision, and service provision. So a report can be made to a county of location, to a county of residence, and statute, General Statute 108A, indicates that the responsibility is on both counties in terms of receiving the report and screening it. However, administrative code states that it is the county of residence that is actually responsible to ensure that the evaluation, the case decision, and any mobilization of services are provided. So that is the basis of what we are talking about in detail today. Okay. Keep in mind, this is not new law. Like I said at the beginning, the statute has not changed, and this is information only. And it only applies to the situations that we're speaking about, only regarding reports on disabled adults who are in a county outside of the county where they actually live. So once we receive that better understanding of how the statute and law applies, at that point, we then develop guidance and practice to reflect that. And we're going to talk a little bit more about that in detail as we go throughout. So that is how we began to have this discussion regarding adult protective services and residency. So at this point, now we're going to hear from Rick, who is going to tell us about how all of that information applies to the adult protective services process throughout.
Thank you very much, Renee, and good morning to everyone, and thank you so much for taking the time to participate in this webinar. We realize that you're busy, and so this investment of time is very important to us, and I hope it will be a good investment to you. As Renee has mentioned, we're going to be looking at the entire APS process. Some of you may wonder if the process is really necessary that we review the entire process, because it may seem that it specifically applies to the receiving and the screening of reports. And yet, as Renee has already pointed out, as the work group began to work, it was realized that the entire process had aspects which were affected or impacted by an individual that may continue to remain in a county of location. And so we wanted to really look at this entire process. As we have that slide on the screen there, you can see that it really covers all the way from the report being made down on through legal intervention, as Renee mentioned, that Raj will be helping us out with a little bit later. But we just want you to realize that there are aspects of this guidance that will affect or may impact every part of the APS process. So with that in mind, let's begin where pretty much all of our APS cases begin, and that's the report itself. So when a report is made, it's important to understand that that report can be made to either the county of residence or the county of location. But I'm going to emphasize this again, and I'm certain that Raj will as well, and that is simply this, that the APS law has not changed. So the mandatory reporting requirements, just like the law, that aspect of it will remain the same. So it is possible that either the county of residence or the county of location may receive this report. In questions that we've received after the first two webinars, it seems like there may have been a little bit of confusion about the process for receiving and screening the report. So I'm going to start off by just stating that very clearly. We're going to talk about screening in just a moment, but it's important that you understand this. As we understand that either the county of residence or the county of location may receive a report, that reporter may choose to report to either county, the county that receives the report should screen that report without delay and determine the initiation time frame. I'm going to say that one more time. So either the county of residence or the county of location may receive the report, depending upon who the reporter chooses to call. Either county, whether it's the county of residence or the county of location, whichever county receives that report would be the county to screen the report and then to determine that initiation time frame. We're going to talk about screening in just a moment, but I wanted to state that from the beginning because I feel like that is really important that we get that into our minds. But in most cases, we're probably going to find that the report will be made to the county of location. But as I said, if it is made to the county of residence, that county of residence would screen it as necessary. Now also, we need to realize that we're training county DSSs, but county DSSs have professionals, perhaps individuals from hospitals and such, that may need to be made aware of this guidance. So as you're doing that, you may choose to share this guidance with hospitals. But keep in mind that just as with any other reporter, a hospital may choose to call the county of location or the county of residence, and this policy, as we've just stated, should be followed, meaning that whichever county is contacted, they would receive and screen that report and make the initiation time frame determination. So after the report has been received, the next step that we're going to look at is the screening of the report. I've covered this already somewhat, but let's just make sure that we are clear on this, that if the county of location has received the APS report, then that county of location is responsible for the screening of that report and determining the mandated initiation time frame. Likewise, if the county of residence has received that report, they would screen and determine the initiation time frame. Keep in mind, though, that this step of screening is completed before contacting the county of residence if you're the county of location and you've received that report. So to clarify that, let me just say, if you're the county of location, you've received a report on an individual who resides in another county, you would receive the report, you would screen that report, you would determine the initiation time frame all before you contact the county of residence. So all that screening process and initiation time frame determination would take place before contact with the county of residence. Once the report has been screened in and the initiation time frame has been determined, then it's important that the county of location share this information with the county of residence as soon as possible. So let's talk just a little bit about that notification process. The county of location, as we indicate and will continue to indicate, should promptly notify the county of residence about that report, and then that county of location will cooperate with any instructions provided by the county of residence. And as you can see on your slide, promptly simply means without delay. We also understand that different counties may consider notification to be in various forms, phone calls and what have you. But it's important to understand that it's imperative that the representatives of the county of residence and the county of location actually speak directly to one another when engaging in either notification of the report or exchanging information that may be time sensitive during the evaluation. So consequently, something like an email or a voicemail or a fax with no other form of direct communication is not a sufficient form of notification that you've received a report or that you need to convey time-sensitive information. So as such, the notification process itself has three components that we'd like to go over with you. And this specifically is when the county of location has received and screened an APS report. So what's that first step in the notification process? Well, the county of location will contact the APS supervisor or his or her designee in the county of residence promptly. And so as we've already indicated, this would mean they would contact them by a phone call. And these efforts are going to continue regularly until the appropriate personnel at the county of residence have been spoken to directly and notified of the report. So keep in mind, if you're a county of location, you've received a report, you've screened it in, and you've established an initiation time frame, you're immediately going to want to contact that county of residence. It may be that you aren't able to reach that individual you're trying to contact immediately. And so we would expect that you would continue to try that call to contact that person, in addition to contacting alternative numbers, maybe calling the main line, trying to get transferred to someone else who may be appropriate to speak to concerning this report that's been received. That's the first step in the process. The second step in the process is once that county of location has spoken to the county of residence and has informed them of this report and consequent screening and determination of the initiation time frame, then that county of location will email or fax the screened-in report to the county of residence. So during that first conversation, the county of residence will inform the county of location how they prefer to receive the actual report. And it could be through email or fax or other alternative methods if there might be some determined by that county of residence. But the county of location will forward that report as soon as possible. The third step in the notification process will be that the county of residence will confirm the receipt of the APS report to the county of location. So simply put, once the county of location has forwarded that fax or email or what have you, it's important that the county of residence in return notify the county of location that they have in fact received the report and are in possession of that information. So keep in mind, though, it's important to know ahead of time whom to call in that county of residence. So be sure, if you're the county of location, to have that information readily available at all times. Now, we noted on the report slide that if the report was made to the county of residence, they are already aware of the report, and they would be making the screening decision, and they would determine the initiation time frame. However, if you are that county of a location, it's important that the county of residence notify you promptly and request your assistance if they need it. So county of residence, if you've received the report, you've screened it, and you determine that you will require the cooperation of the county of location, you'll need to contact them as soon as possible so that those time frames can be met. So once again, without delay, you need to contact county of location if you're requesting their cooperation, especially in the initiation of the APS case. Next in the APS process is the case initiation. So let's look at that a little bit and see what implications that this guidance may have on that. If the county of residence determines that it will require assistance with the initiation, it will ask the county of location for their cooperation. However, if the county of residence is able to initiate, it will do so, but later on may request assistance from the county of location as needed if the individual continues to be in the county of location. So if the report made to the county of location is determined to be emergency, how would that county of location handle it? Well, if it's an emergency, then the county of location is required to initiate immediately and notify the county of residence simultaneously. So let's get that picture in our minds. If a county of location has received a report and that report is pertains to an individual who is a resident of another county, they are going to screen that report and they will determine the initiation time frame. If in the determination of that initiation time frame they determine that it needs to be initiated immediately, then two things are going to happen concurrently within the county of location. That county of location is going to have a staff member initiating that APS case immediately, and concurrent with that, that county of location should also be attempting to notify the county of residence. So two things are occurring when there's an immediate time frame on that initiation, and that is the county of location will be initiating the report or the case and also trying to contact the county residents to notify them of the situation. So if the initiation is done by the county of location, it's important to note that it will be conducted with adherence to the law and according to the rules and the standards of best practice. In plain words, there should be no difference in the quality of APS work done, whether it is for the resident of the DSS county or for another county. If the situation is determined to constitute an emergency, it may be necessary to immediately contact law enforcement and or the district attorney. So under such circumstances, it would be the responsibility of the county of location to do so. Let me clarify that just a little bit. Generally speaking, reports and notifications are going to be the responsibility of the county of residence. However, if the county of location determines that an emergency exists, that an immediate initiation is necessary, it may be necessary then in that case for the county of location to contact law enforcement for support or perhaps even the DA or other entities as needed. And it would be the responsibility of the county of location under those circumstances to do so. The next step in that process as we follow through the APS evaluation is the evaluation itself. And so let's look at that a little bit. The county of residence, as Renee has already mentioned, has the responsibility to ensure that a thorough evaluation is conducted, including the review of the victim's circumstances and the functional domains, the contact of all collaterals, medical evaluations, etc. Also, the county of residence is responsible for the case decision and any appropriate action following that case decision. So if the APS victim continues to remain in the county of location during the evaluation, it's possible that the county of residence may continue to request the cooperation of the county of location for the completion of the evaluation. But keep in mind, the county of residence is asking for the cooperation of the county of location, but the responsibility for the case decision and provision of any services that may be deemed as necessary would be upon the county of residence. In turn, the county of location will continue to report findings to the county of residence as they cooperate with this evaluation while the victim remains in their county. It's important to be timely in the conveyance of the information between counties. Therefore, while written documentation should be shared on the appropriate forms, it may be necessary to, first of all, share these findings verbally if the information is time sensitive. Our recommendation is to share all findings in writing within 7 days of their acquisition. But keep in mind that it may be helpful, as I've noted, to have this information verbally prior to the written documentation. So let's just talk about this very simply, and that is, if a county of location is cooperating with the county of residence and they may conduct, say, an interview with the victim or another collateral, they need to share that information in writing with the results of their contact within 7 days to the county of residence. However, if there's information which is pertinent and important to share prior to the conveyance of that written documentation, then the county of location really needs to call the county of residence up immediately and share that verbally so that they have that information at their disposal. A good example of this may be if the victim has been in the hospital, say, in the county of location, and the county of location in their contact with the hospital personnel realize that the victim is being transferred or being discharged from the hospital back to their county of residence, it would be important to notify the county of residence immediately, verbally, instead of waiting for perhaps 2, 3, 4, 5, or up to 7 days to share that in written form. So something that's time sensitive such as that should be shared as soon as possible verbally with the county of residence. So the next thing that we want to address briefly, and we've touched on this a little bit already, is communication between the counties. It's really important to understand that concise, thorough, and timely communication between the county of location and county of residence, that it's essential to the completion of a proper APS evaluation. We can't overemphasize the importance of good, concise, thorough, and timely communication. So it's important that this communication between the county of location and the county of residence is clear. So one way to ensure that you have a clear record of this is to make sure that you always document the date and the time of conversation with personnel from other counties. Keep in mind also that the county of residence should advise the county of location of the preferred method of receiving information. And we mentioned that before, that during that initial notification, that county of residence will determine and let the county of location know if they'd like to receive this information, say, through email or fax or phone or another method. So communication, extremely important. The last thing we want to touch on, and this really projects out into the remainder of the evaluation, and even if that individual, the victim, continues to stay in the county of location, is the follow-up on whatever may be needed after the initial contact and what have you. So some things about follow-up. The county of location, as I've mentioned, will verbally share any findings with the county of residence and follow that up with written documentation within 7 days. So keep in mind that that may continue for as long as that victim remains in the county of location. County of residence may choose to visit that APS client themselves, or they may ask for the cooperation of the county of location. But those findings will continue to be shared by the county of location. And then also, any updates or additional information should be shared as needed by the county of location with the county of residence. Now, after having gone through the process, we're going to look specifically at some of the aspects of legal intervention, and Raj Premakumar is going to be sharing that with us. Raj?
Thank you, Rick, and thank you all for joining us this morning on this webinar. As both Renee and Rick said, this development of this guidance involved the hard work of a lot of folks from both the state and the county level, and we appreciate the opportunity to discuss this with you today. With respect to legal intervention, as has been stated before, all of this arises out of a distinction that has been made, or a clarification that has been made regarding the interpretation of the administrative code, which governs the Adult Protective Services process and procedure, and specifically that the county of residence is financially responsible for the evaluations and also responsible for the legal expenses that are incurred in providing protective services. And so it makes sense that the county of residence would be the responsible party when it comes time to file, if it is needed to be filed, a petition for protective services. And essentially what the county of residence has is both legal jurisdiction and legal responsibility to make those filings. As Rick outlined, there is cooperation that's occurring here, and cooperation can continue beyond the point of a filing of a petition. Obviously, there's the responsible party, which is the county of residence. But if there is information that the county of location has developed, in the best case scenario, you'd have a representative, the person who developed that information from the county of location, present at a hearing. But if that person can't be present, a sworn affidavit can be used by the county of residence in its petitioning process and in its hearing before the court as evidence to be presented to justify a protective services order being issued. The standard, of course, in a hearing is clear, cogent, and convincing evidence that a disabled adult is in need of protective services and lacks capacity. And to the extent that that information can be presented to the court in the form of an affidavit, it is acceptable. It is acceptable evidence. So basically, what we're trying to do here is we're trying to coordinate the proper jurisdictional role of the county of residence with information that may have been developed by the county of location in cooperation with the county of residence. But ultimately, the county of residence is responsible for petitioning, and that is the responsibility of the lawyers at the DSS of the county of residence to do. And I think I want to add here that this situation is not going to be the predominant situation. In other words, it is not going to be all that often that you see a person who is a resident of one county finding himself or herself in the county of another county and an APS report being made. Typically speaking, it's all going to happen in one county. But in this situation, particularly in situations where there are hospitals involved, as many of you are aware, or all of you are aware probably, that hospitals can take people from all over the state, and that sometimes results in situations in which the hospital staff determines that there may be a need to report a possible APS case, and that's where this whole process gets started. So that really is sort of the sum and substance of the legal responsibility portion. There may be some questions that you have specifically related to the procedure, and if you do have those questions, I'd be happy to answer them at the end of our presentation today. But I'm going to turn it back over, I think, to Renee.
Thank you, Raj. Yes. Okay, so now we will review the tools that have been developed as a result of this guidance. The first tool that we'll take a look at is the actual flow chart. And the flow chart is actually a part of the Appendix V, as you see. So I'm in the Appendix V, and it's at the very back of it. So here is the flow chart. And we developed this as a visual snapshot of the process. It actually shows you the steps and reminds you of the steps to take when you are receiving these types of reports. As you can see at the very top, the process is the same as we've been saying in terms of when a Department of Social Services receives a report of a disabled adult. And so you apply the same screening process as always. You decide whether or not it meets the APS criteria. And then if it does, at that point is where you will make a determination or look at the information that you have obtained from the reporter as to whether or not the adult is actually a resident of another North Carolina county, but they're actually present in your county. Okay. So as you can see here, the flow then begins to go on throughout the process as Rick has already talked about. I want to bring your attention over here to the left-hand bottom side, the definitions box. Here's where we just put definitions that we've always had in regards to certain words or terms, but we also added, as you can see, we've been referring to county of residence and county of location all throughout. So for short, we just call it the acronym COR and COL, and that's self-explanatory. Rick already talked about prompt. The definition for prompt is without delay. Just want to point out here that there is no time attached to that. It just means as soon as possible. Just without you just move forward without any delay. And here we have the definition for cooperate. Just want to highlight that because you need to be aware that this is cooperation. These types of situations are not considered a courtesy. So if the county of residence is contacting county of location and asking for assistance, then you are cooperating as required by administrative code and rules. You're not assisting them or providing a courtesy. So that helps to put that in perspective there. In terms of residents, here you can see we cited the ruling for that, 153A-257, which is the legal residence for social services purposes. Residence in this situation is referring to the person where the person calls their home, where they have lived. In situations where they are a resident in a facility in a county, then that county is going to be considered their county of residence. That county would handle that adult protective services report and process. In terms of other situations, if a person is in a county, but they actually have a residence in another county, then that is what we're referring to. I want to also point out that county of Medicaid does not automatically dictate a person's county of residence. It could be a good starting point for the county in terms of when you're trying to research and determine what county is actually that person's home. But it is not and should not be a part of the process in terms of when you are deciding whether or not that's that person's county of residence automatically. So I'll just wait to hear for any questions you may have regarding how to define residence when we get to the Q&A session in just a bit. So that's all I wanted to point out here on the flow chart. And as you see at the very bottom, we have indicated what we've discussed all throughout, which is that the county of residence is responsible for the evaluation, any required notifications, and any required notifications with the exception of, as you can see up here, if it involves an emergency, then that county of location should be doing any notifying of law enforcement and or district attorney. But on the regular, the most common situation will involve the county of residence being required for notification. Also, case decision and mobilization of protective services. I also want to point out here, if the county of residence cannot be determined, then it's going to be the county of location's responsibility to provide those protective services, evaluate, and move forward as needed. Okay. So now that we've talked about the flow chart, let's go back up to the actual body of the appendix. And want to let you know that the appendix, along with the flow chart, will become a part of the Adult Protective Services Manual. We are working on reissuing the entire manual. We have not done that as of yet because we are continuing to still work on another section, which is the intake and screening part. And so once we complete those edits and revisions, then we will reissue the entire manual, and you will see that the Appendix V will then be a part of the Adult Protective Services Manual. But in the interim, you have this separate document to refer to as you need to. And the appendix just gives you the step-by-step procedure, as already explained by Rick and already captured on the flow chart. It just provides a clear step process for the counties to be able to follow the process as needed. Okay? So now we will move on to the Adult Protective Services Manual language section. So as I already stated, once we reissue the Adult Protective Services Manual, we will also include this section in the intake and screening section, which clearly states it is referring to this particular situation. Adult Protective Services Residency Manual section. So this is for Adult Protective Services reports received when a disabled adult is not located in the county of residence. And again, here we are capturing all the information that we've been discussing, indicating that at that point the county is responsible for following this guidance as reflected in the appendix and on the flow chart. So once the Adult Protective Services Manual is reissued, you will see that this part will be in there as well. And then the last part I want to just talk about a little bit is the actual Adult Protective Services intake tool. We made updates and I revised this to include this guidance. As you will see on the very first page here in the highlighted area, we've added an area for you to indicate information about that person's residence. And then also current location as well. So you would fill in as appropriate and as that information applies to that particular individual. Here you will see in item Z, we also added the ability to, when you're gathering information about collateral for the individual, you can, over here in this section, indicate if it is attached to that person's county of residence or if it's attached to the county of location. And there's a drop-down box here where you can actually indicate which one applies. So that reminds me of something else. So let me just stop momentarily and just bring your attention to, we are aware that there are some functional issues going on with the reissued APS intake form. We are working on those internally, and we will reissue this particular form out for everyone once we make it, once we correct those errors. So for anybody who is trying to go through the form and you're stumbling and you're not able to actually fill in certain areas, we are aware of that and we're working on it. So I'm just going to continue going on down to show you the other revisions made all the way to page 6 in the disposition of report area. So here in item D, you will see that we added an opportunity for counties to capture, again, whether or not there's information in this particular report that the adult is a resident of another North Carolina county, and then you can actually also indicate which county is their county of residence. Here you are able to capture how you communicated with the county of residence supervisor or their designee, whether or not you did that, and when, date, time, the person's name, and the method. And then you can see the other items as it applies. So here's this, like I said, we updated the form so that you wouldn't have to create another method of being able to record keep. This information is already captured here and included in the APS intake form. Okay. Moving on down to item F. So I want to take this time to just remind everybody that the Adult Protective Services annual survey will be coming out this month. And for those of you who are not familiar with that, the annual survey is sent out to all 100 counties annually, one time every year. And it is how we capture data that is not actually captured in the Adult Protective Services register, the system where you actually key your 5026 forms into. The survey captures information about all of that outreach and follow-up and information and referral that you all do, but is not necessarily captured in any other way. So you will see here in this section of the new intake form, we have included opportunities for you to be able to capture that information. Hopefully that will assist you going forward in completing your annual survey results. Okay, so here you indicate whether or not you actually assigned that report or accepted it for evaluation, or whether or not you assigned it as an outreach or information and referral. Okay. Here, this item G, of course, is the same in terms of response time. Item I, here we added a secondary screener signature. Just be aware that this is optional. We're not saying you have to have that. It's recommended, it's optional. And it can be whomever your agency determines would be an appropriate person, whether it's another member of management staff, or it's a social worker, intake social worker, whomever your agency feels is best for your area. Okay, then here in item L, you see that we added Division of Health Services regulation in terms of the notifications and the adult home specialist, in addition to district attorney and law enforcement, of course, and then also an area for you to capture any other notifications that may apply to that particular report. And then in item M, again, which hopefully will be helpful for you filling out your annual survey results. Here you actually can indicate whether or not a referral was given to the reporter for community service, and if that was the case, you can actually list the agencies that you talked to that person about or that you provided the information about. And here's an opportunity for you to also document if there's any in-house referrals made for that report, and the actual unit or department, and the information, as well as the expected follow-up. So again, hopefully this new section here will be very helpful for you all moving forward. So that's it for the intake tool. So we'll get back to our PowerPoint here. And that brings us to the question and answer session. So I will check to see if we have any questions at this time. Okay, first question, how and where is residence defined for these purposes? We run into situations where an elder stays in one county, either in a long-term care facility or with family members, but owns property or a home in another county, or originally received Medicaid in another county. How do you determine the adult's resident in that situation? And I think I already spoke to that. Hopefully the person that typed that question got the answer, but I'll just review it again. Medicaid, county of Medicaid is not the necessarily indication of the county of residence. And if the person is in a facility, then that county is going to be responsible for that report.
Yeah, and if I can just jump in, Renee,
sure.
On that point, there's actually a very helpful code provision that makes that distinction clear. There is a code provision that specifically applies to residential care facilities, and it says, and I'll just read from it, the department in the county in which a nursing, combination, or residential care facility is located has primary responsibility for providing protective services to adults in that facility. So in the context in which someone is in a long-term care facility or a nursing home or a combination facility, this whole process really doesn't need to be applied because the county in which the county in which the facility is located is the county of residence for that person based upon this code provision.
That's right. Thank you, Raj. Okay, so we'll move on to the next question.
Renee, excuse me, this is Nancy.
Sure.
And just to, and just to say too, regardless of whether or not that resident of a facility has property in another county, that's not going to apply. The rule that Raj just read makes it real clear. So all those other factors won't apply in the situation where a disabled adult is a resident of a long-term care facility as defined in that rule.
Okay.
Yep.
Thank you. Thank you. Okay. Next question. Is there anything on conflict of interest cases? I'm not really sure what.
Well, if the conflict of interest is concerning, there was already the I believe the process where if there's a conflict of interest and a person has a report of adult protective services and that person is related to the director or someone in the county, there's a process by which that can be transferred, I believe. Isn't that correct? So that wouldn't apply in this. This is sort of not addressing conflicts of interest.
Mm-hmm.
The separate procedure by which
right.
one would divest, a county would divest itself of the responsibility of pursuing that report if there's a conflict. So I guess what I'm saying is this does not address a conflict of interest. That's addressed separately.
Right. I would agree with you, Raj. That's my understanding. Okay. So we're going to move on to the next question. So it looks like a lot of you had a lot of questions about that facility, so I'm glad we cleared that up. Who notifies the reporter that the report is accepted or denied? And that's going to be the county of residence. The county of residence is responsible for notification. Next question is, how do you determine residency for homeless adults? So I'll just go back to what I said before in regards to if the county of residence cannot be determined, then it's going to be the county of locations report. Okay. Next question. Do we share SIS numbers with other counties, or do each county have their own SIS numbers? Okay. And we've had a lot of discussion about that. Glad you asked that question. I had meant to include that, to make that a point anyway. So the county of residence, like we've been saying, is responsible for the evaluation process and case decision. So they are the ones that's actually going to complete the 5027 form and obtain a SIS number. That SIS number can be given or shared with the county of location for any activities that the county of location performs on behalf of the county of residence for that particular report. So the county of location will not complete 5027 nor or request a separate SIS ID number. The county of location will use the SIS ID number that the county of residence has. Okay? So hopefully that settles that question. Next question, what determines county of residence, or what amount of time in a location makes the county of residence? There's no specific amount of time when we're talking about residence. You know, again, like we've already discussed, is going to be based on where that person calls their home. There's no specific amount of time, for example, that they have had to live there for 5 years or 5 months. It is just where that person indicates is their home.
Yeah, the statute is not very helpful, as oftentimes, statutes can kind of be circular. So the actual definition of legal residence is a person has legal residence in the county in which he resides, which isn't necessarily particularly helpful. So I think it's a constellation of factors that you have to evaluate in terms of, if they have a home and that sort of thing. And Renee is correct. There isn't a time that is associated with that determination. It's one that you'll have to make based upon all the evidence that you're able to gather regarding where that person resides.
This is Rick. I think it's just important for counties to understand, too, that this determination of residence is going to be based upon the information received from the reporter. And really there's two aspects to that. Number one, the reporter may only have a limited amount of information. They may have an address of where this particular individual has referred to as home. Likewise, they may not have that. And so we're not talking about the county location or the county receiving the report really having the luxury of a lot of time to try to research to find out. So really what we're going to see oftentimes is the need to make a screening decision as soon as possible, and if based upon the limited amount of information that is received from the reporter, that county of residence is unclear or really can't be determined, then that county of location is going to have to move forward with the understanding that, according to our guidance that we're providing today, that county of location, county of residence really can't be determined, and then they would assume responsibility for the case, the evaluation, the decision, and any services that would follow. So many times it's just really not going to be a situation where they can research or pinpoint exactly where the residence is. And so that's the real truth of what often happens when a report is made.
Okay. Yes, thank you, Rick. Okay. Let's see. Do you have to notify even if the case is screened out? The answer is going to be yes if they requested to be notified, if the reporter requested to be notified. Just like the normal process, if I'm reading that question correctly.
Renee, this is Rick again. I believe that the person who submitted the question may be referring to, does the county of location, are they required to notify the county of residence that they've received a report and that has been screened out? Okay. And I believe under the circumstances it's going to fall into that discretion of the county of location, just as the need to provide information and referral or some type of follow-up to that. Certainly there will be circumstances, and I believe that in a previous webinar that Nancy really described this very well. If she may have some thoughts on this, but ultimately that county of location will determine whether they believe that it would be important to share about a screen out with the county of residence, if I understand their question correctly. So that would really be the determination of the county of location if they feel it's necessary to share that information with the county of residence.
Mm-hmm. Mm-hmm. Thank you. Okay. Next question. So it's okay to bill for same SIS number on the same day with two different numbers on one client? Yes. You can use the same SIS number that county resident has. Now the difference, of course, you cannot open any services and should not open services. This is not a transfer of service, or you're not opening, the county location will not open for services. You're cooperating with the request by the county of residence who has and will open the service. So yes, it is okay to bill on the same day with the same SIS number for one person. Okay. Next question, does the county of residence or county of location complete functional assessment, call collaterals, obtain medical information from doctors, etc.? Okay. And just like you, Rick, was you talking? No, okay. Just like we said before, that is going to be a plan that is made between the county of residence and the county of location in terms of who will do what. It is all based on, once you make that initial contact with the county of residence, then they're going to dictate or prescribe what happens next, what pieces they need or like for the county of location to complete. Okay.
This is Rick again. If I can just add to that, we've stated that the ultimate responsibility for the case decision is going to fall upon the county of residence. So as such, what we would understand then, that all the information used in the determination of that case decision, whether it be contacts of collaterals, obtaining medical information, regardless of whatever it may be, and regardless of which county, the county of location or the county of residence, regardless of where that information has come or which county acquired that information, the county of residence would need to have, so to speak, within their possession or at their disposal, and, probably as such it would be contained within the record, all that information would be available there. And so they're going to need to have that information to conduct what we consider to be a complete and thorough evaluation, and as such then to be able to make an informed case decision. So while both counties may gather information, the county of residence is going to be the county which would have all of that at the time of the case decision in order to make the best case decision of a complete and thorough evaluation, and then the ensuing case decision which would result from that. So both counties are gathering information. The county of residence is going to need to have all that information at their disposal to make the final case decision for which they're responsible.
Okay, thank you. Okay, the next question, what if the adult is in the hospital for the entire 30 to 45 days out of the county of residence? Who would be responsible? And that's still going to be the county of residence.
Right, that's correct. The statute that applies to long-term care facilities that does not include hospitals. So hospital stays are not, as Renee said, if the person's in the hospital, it's still the county of residence that has primary responsibility over the APS both the case decision and then any subsequent legal protections or legal procedures that need to be implemented.
Okay. Thank you. Next question. If the county of location is not opening a 5027 or 5026, then how is the county of location going to track and report this time on the APS survey? Nancy, if you're at a point where you can chime in, do you have any thoughts on this one? She may not be available. Okay. Rick, do you have any thoughts?
Renee, and this is based somewhat on some guidance that Nancy has provided in a prior webinar, and simply this. The 5026, as the writer of this question has indicated, the 5026 is going to gather information about the case as a whole, and obviously the 5026, all those data points that are gathered in there will be reported to the DAAS through the 5026 form. However, and this is a really important point, there may be aspects of work that was done by the county of location which may not be captured on the 5026. So it would be important for the county of location to include any important pieces of information that may be appropriate to be included in the annual survey. So they would do that on the annual survey. For instance, one of the things that we all know is not included on a 5026 are cases that were screened out. And so we know that that information needs to be gathered and put on there. Likewise, if there's pieces of information that are not included in a case like this where there's a county residence, a county location, and that county of location wants to include that information on the annual survey, that would be an appropriate way to document there. And not only that, but the counties may choose to document their work on this case internally for other purposes. For instance, even though they're not filling out or completing a 5027, they did receive and complete a report. And so for their internal monitoring, or their internal records, they would want to count that as a report that they received and made a screening decision on. So ultimately the answer is yes, there would be times and it would be appropriate when pieces of information regarding to the work that a county of location has done on a case would be included in the annual survey. Renee, am I making sense to you, or are there things you might be able to add to clarify that?
That makes sense. That makes sense to me. Okay. And I just want to add at this point that we will compile all of the question and answer sessions from all three webinars and create one document for all three and send them all out and make them available for everyone, in addition to a recording of one of the webinars. So just look for that to come. So if you haven't been able to get some of the information, or you're concerned that you're trying to write down all of the questions, you don't have to, because we will be sure that you get it. Okay. I'm going through the rest of the questions. We've already answered most of them. A lot of them are repeats about facilities. Okay. What is the county of resident's responsibility to have a face-to-face with a client if the county borders the county of location county? Oh. Okay.
This is Rick again, and I'm not sure that I'm understanding the question, but if I am, it was stated at the very beginning that the APS law 108A provides a clear indication that both the county of residence and the county of location share a level of responsibility in the completion of the APS evaluation, even though we've made it clear that the actual case decision, the determination of protective service would fall upon the county of residence. So if the county of location is unable to, or is it's not practical, or it may be even logistically impossible for them to initiate, and part of that initiation is a face-to-face meeting with that victim. If they are unable to do so, that is why the guidance is provided that they would communicate to the county of location their need to have the county of location complete that phase or that requirement. And so as such, then the county of location would be asked to cooperate in the fulfillment of that requirement to complete a face-to-face meeting. So in such, as I mentioned earlier, all that information, all those activities will be compiled together in the final case decision, and therefore the county of location may be the entity which has completed that face-to-face with the victim. And so as such, it would be, they would be fulfilling that requirement. So if the county of residence is asking, what if they don't do it? Are they still meeting that requirement? Certainly, if the county of location has been requested to cooperate with that and they complete that, it is as if that county of residence has done it, because by proxy the county of location has done it through cooperating with that request. I hope that makes sense, and I hope I've understood the question correctly.
Thank you, Rick. Okay, and that does it for our question and answer session. So the last thing we have to share with you today is just some additional resources to help you as you move forward with this clarified guidance. Any questions regarding the actual implementation of the guidance can be addressed to the Division of Aging and Adult Services via the listserv. And here you see the listserv email address is listed for you. And then in addition to that, Amy Wall with School of Government, who advises and trains the Department of Social Services and county attorney regarding adult protective services, she created a blog, and it's entitled Adult Protective Services, Which County is Responsible. It's very helpful. Even though, like I said, the audience that it was written for was for county attorneys, DSS attorneys, the information still applies and is very helpful. And you can view the post by going to that particular link that is listed here on the slide. So that's just some additional information for your convenience and reference. Okay. So at this time, we're just going to wrap up. I just want to, again, in addition to reminding everybody that the annual Adult Protective Services survey will be coming out soon. Also, we are gearing up for our fiscal year 16-17 adult services training. So the training calendar will be coming out soon as well. But in particular, I want to bring your attention to adult protective services training. Because we're kind of all maybe just 3 weeks away from the very first one. And I want to go ahead and share that information with you all so that you can do what you need to do in terms of planning if you need to have staff attend the first one. The first one is September 1st and September 2nd, and it is in New Bern, North Carolina. We are working very hard to make sure that the registration is open to receive registrations for that particular training this coming Monday. But just look, pay attention to your emails. We will, of course, notify you when registrations are open, not just for adult protective services training, but all adult services training. But again, because the very first APS training is so soon, I wanted to at least make you aware of it during this webinar. Okay, so again, just look forward to more information to come. We will send the Q&A list out in addition to a recording of the webinar so that you will have that information to refer back to. And then in the future, the Adult Services Manual, Adult Protective Services Manual, will be reissued as well. Okay, well, we thank you so much for your attention today, and we'll go ahead and say goodbye. Thank you.